Okay, so we have our five. Thanks to Cindy being on our bench, we have a full board. Thank you. Next item is the quasi-judicial announcement, and we have the city attorney here tonight. Mr. Daniel, would you care to make an announcement?
I would, and before we get to that announcement, I was speaking with Ms. Irwell before the meeting, and item number 5 on your agenda, application 15-99 at 119 South Spring Boulevard. As you know, I don't ordinarily cover this board. If it's all right with the chairman, could we move that so I can speak about it now? So
Sure, yes, please do.
And I think the applicants are here. I reviewed your application. I don't ordinarily cover this board. It's done by an associate out of my office. She couldn't make it tonight. So I had the opportunity to begin reviewing this agenda a little bit later in the afternoon. And I spoke with Heather. And it is my opinion, after having reviewed the documents, that a variance is not required for your project because it does not expand the nonconformity in the setback. You have vertical construction. You're not going further into the setback. The other dimensional requirements in the zoning district are met. So from a technical perspective, Heather can speak to what's going to happen. But my opinion that I gave to Heather today is that no variance is required.
And that being the case, we'd like to request from the board that we withdraw this application so that we can refund the application fee to the applicant so that they don't have to pay that burden since the variance is not warranted. And so that's what we would like to see.
You don't, so long as the applicant consents to the withdrawal.
So
We're happy to keep your money, but if you want.
we'd like to thank the applicant for coming, and if you guys give me a call tomorrow, or I'll try to give you a call tomorrow, we'll talk about the refund and the process that goes along with that so that you'll get your refund back, because we did have to pay for the advertising for the thing, so you won't get the advertising fee back, but you'll get the application fee back, which is the larger of the two. So, and with that, I can also talk to you about, your next step. Okay?
Thank you, folks. Sorry for the inconvenience of coming.
Congratulations, I guess you should be. Oh.
Good night, kiddies.
For the record, that was for the
You got the whole floor.
application number 5 for 119 South Spring Boulevard. For those out there in cyberspace, it's the old Capsalis home on Spring Boulevard. So next, Jay, you want to go back?
All right, Mr. Elliott, instead of making the full quasi announcement, I know this board is well experienced in quasi judicial proceedings. I'll ask for anyone who intends to testify this evening to please stand and be sworn, which I assume would be the remaining applicant. And I know it's like school, right? You've already got your right hand up. You've done this before. Do you solemnly swear or affirm that the testimony you'll give tonight is the truth, the whole truth, and nothing but the truth?
I do.
The way this proceeding will work, folks, is that the city staff will give their presentation. You'll have the opportunity to cross-examine the staff if you wish. You'll have the opportunity to make your own presentation. The city staff will have the opportunity to cross-examine you if staff desires. The board will take the matter under consideration, ask any questions that they deem appropriate for their consideration of the matter, and then they'll take a motion and vote. It's hopefully be relatively painful. That being said, sir, everyone's been sworn.
Thank you. We had a preliminary discussion about the minutes, and we're going to defer that to the end of the meeting, if that's agreeable with everybody.
Sure.
And I was listening to the YouTube just to get some ideas as to how we can improve, and the speakers last month, including myself, we didn't come off very well on the audio portion. I mean, I looked as ugly as ever in the video portion, but if we could use the mics when we do speak, I think that would be okay. Is that what comments concurred there? Okay. All right, the next item then is number 4, which is 1654 Seabreeze Drive. Applicants are present. Ms. Erwiller, would you care to make some comments, please?
Sure. The application is to authorize a variance to reduce the side yard setback to 17.10 feet to allow construction of a garage and a sunroom addition in the R100 district. R100 district has a required setback of a minimum of 10 foot on one side and a combined setback of 25 feet. In this particular case, what has happened is this property was built prior to the 1990 code when the R100 district changed their setback standards for those side yard setbacks. That being the case, the home the home on that property is a non-conforming structure. There's a question as to whether or not the lot is non-conforming itself. In this particular case, the plat shows it as 10,000 square feet. However, the survey shows it as less than 10,000 square feet. I really don't want to get into the argument about that because it's really the question here is really a question of the non-conforming structure itself and allowing for this additional sunroom and garage to be in line with the existing wall of the house, which right now currently has a setback. If you refer to the site plan, it's a combined setback of 17.10 feet. However, if I find my thing, as you can see on the drawing here, they have an existing setback on the side where the sunroom and garage addition are going to be of 9 feet. And so there's where the variance comes in. The maximum minimum setback that you can have on either side, in this particular case in R100, is a 10-foot setback. So really, the function of the 17.10 setback is to essentially approve their existing setbacks that are on there, and they want to build the garage and that sunroom in line with that existing wall. Being that this is a not vertical construction like the last variance we had, this is a footprint issue. In speaking with Jay, in this particular case, the expansion of the non-conforming structure requires the variance request. Staff has looked at this, and unfortunately, the basis for a variance when staff goes through their analysis is a physical hardship of the property. There isn't a physical hardship of the property. Here, it's really a historical condition that was done, and the home is an existing non-conforming structure, so staff doesn't have a justification for a positive recommendation. So based on that, staff's going to read you their findings of fact and go over their recommendation, and then we'd be looking for this board to render their decision. Basically, our findings of fact are the house was built in 1962 prior to the adoption of the current R100 dimensional criteria. The hardship for the variance is not a physical hardship of the land. The request is based on the house being built prior to the current land development codes R100 dimensional criteria being adopted. The granting of the variance would not extend any special privileges to the applicant. Other homes in the area also enjoy reduced setbacks. However, all new homes would have to meet the current land development code dimensional criteria. The granting of this variance would not hinder the character of this existing neighborhood and would not create a nuisance. And the request generally conforms with the intent of the LDC with the exception of the setback on the side and the policies of the comprehensive plan. Because of the fact that it is not a physical hardship, which is the basis for our variance, the staff recommends denial of the request to allow for the construction of the new sunroom in the garage having the combined setback of 17.10 feet, as it is not a result of that physical hardship requirement of the land. And it does not meet the criteria. I can't make a positive finding on each one of the criteria in the land development code section under variances, and for that reason, staff cannot support it. And I can answer any questions that you might have.
Okay, thank you. The next item of procedure would normally be the applicant's right to cross-examine our staff member and state your own case. But I would like to know first, have there been any comments from adjacent property owners?
I have received no comments from adjacent property owners, and the property was posted well before the 15-day minimum requirement. I actually had the sign out there about 20 days ahead of time or so. So there has not been one phone call on this particular application, either for or against the application. So being that there's other homes in that neighborhood that also enjoy these reduced setbacks, that's more than likely the situation that they're aware of that fact.
Thank you. And for the record, there's nobody in the audience to object one way or the other, for or against. Okay, is this Mr. and Mrs. Green by any chance? Or?
Mr. Green.
Would you please get to the podium and state your case? And you have the right to question
Okay.
anybody you want.
My name is David Green. I'm not related to the owner of this property. I'm going to be the contractor for the owner. I get the honor of meeting with you this evening. The house was built, needless to say, in 1962. When it was built, it conformed to the setbacks required by the city. Since then, the city has changed the setbacks, and now they're taking a house that had met all of the criteria to be built on this lot and saying now it's a non-conforming use because they have changed the requirements. We have met with the city. They're looking for an overall side yard setback. I think it's of 25 feet.
Correct.
I have a survey here. If you go from the 9-foot side yard, where it shows a wood deck now, which will be the existing sunroom, we're going to move it over, and go to the other side of the sunroom, we have 25 feet there for an overall length of 34 feet. Now, you're shaking your head, why?
Essentially, the setback is measured for the closest point of the house to that property line. That is how your setback is measured. So
Okay.
it's whatever those closest points
Okay,
are.
but okay, then, if we take that sunroom and move it in 7 feet, like we were talking to the Michelle downstairs and all of that, by bringing it in that 7 feet, how would that change the closest point of the yard? It doesn't. It still leaves it the same.
As long as the setback is met from the edge of the structure, the minimum setback on that side, okay, would be 10 feet, okay? So if you come in 1 foot and
Okay.
you can make up the difference on the other side, but you can't make up the difference on the other side because you don't have 15 feet on the other side. So in that case, you have to meet the criteria for the minimum setback between both of those things. Since you've got an already reduced setback on the one side of 8 feet, you would have to make up for the additional feet that you're missing there on the other side. So that puts that at 17 feet rather than the 15 foot that's required. Had this house been at that 10-foot line on that side, then you would be less encumbered on that particular side.
Yeah.
But because of it, you have to add those extra 2 feet to that setback and extend that setback.
Yeah.
And that, I don't know that that's going to help you with where the garage and that type of thing is, because the garage is also in line with what's existing out there.
Sure.
You know, with your driveway and that type of thing. So,
Yeah, again, you know, unless this house is torn down and rebuilt,
I agree.
there's no way you're gonna get this house to conform. Even if we came in the additional 7 feet on each side, you still say it's a non-conforming use. You're trying to bring in a house that was should be grandfathered in on your setbacks.
But it is, I'm sorry to interrupt you, sir.
Yeah, it's all right.
It is grandfathered in terms of the present nonconformity. What the
Well,
code,
I
what the
don't-
code provides is that the nonconformity cannot be increased, and that's what the application
Yeah.
is seeking to do.
Yeah. So basically, you know, I have nothing else to say about it, so.
I'm sure the board has got a bunch of questions. I do too. I'll defer to anybody else though, unless you want me to start.
I will.
Okay, Chris.
Thank you.
Mr. Ella, who's this?
Yes. It was mentioned earlier that when the lot was platted, it was 150 by 72, then later became 126/72. How can you have so much difference from the time the lot was platted to the time to currently survey? How can you do that?
It depends on the,
The water.
yeah, it's on the water. So what happens is, depending upon when that seawall was put in, that concrete seawall was put in, that property from the time that it was platted was having water action against it. So unless that seawall was actually placed in the correct place, and again, survey methods from 1962 or prior to 1962 are very different than survey methods done today. Today, it's GPS located, so it's a much more accurate depiction of a legal description on the ground. So that's where those discrepancies come in. And so rather than challenging the survey, that's really not the issue here, is the non-conforming lot. It's really this non-conforming setback that's the result of action taken by the city to, in the R100 district, to do those setback, to change those setbacks. So that's really their issue here. It's not so much the fact that the lot's a little bit smaller than the minimum requirement.
But even though they shouldn't have any effect as far as what the variance would be.
Correct, because where they're actually losing their property is not in the area where we're talking about that setback. It's up by the water is where the discrepancy really is.
Another question to ask you. You see that as a regulation issue, but do you see that as a planning problem?
I think it's a difficult situation, especially in this particular neighborhood. The R100 district has specific standards. You have lots out here that are just barely making that minimum lot size, and because of that, it makes it very difficult, because in 1962, we had a very different lifestyle than we have in 2015, and people's needs and desires for space at their house are different, than they were back at that time. So that being the case, this is a difficult lot to make the changes that need to be made within the code, because you have an existing house. Now, they certainly could build vertically within that footprint, but that's not going to work with what their request is here. It's not a question of just, adding an addition. That would be adding in a whole new house, essentially, on top of the existing house. So it's fundamentally really not a planning issue. It's just, as a community, we decided that these are the setbacks that we want to have in R100, and we have some subdivisions in the city that have homes that were built prior to those regulations coming in, and it creates difficulty when people want to expand their houses.
Do you think our code should provide provisions for situations like that?
That's what this board's function is. This board's function is for people who, in a case that they need some type of deviation from those code, this is their opportunity to come and ask this board to do that. As staff, I am completely bound by by this code. So I have to look at this code and Florida statute and determine from that whether or not it meets the criteria for a variance. And based on the review here, I certainly understand their situation. I certainly can relate to this situation, but there's not a physical problem with the land that makes this variance or warrants this variance. However, your code does allow for you to review variances for non-conforming structures and non-conforming lots. So that's why we're here, because of this alteration is an expansion of the footprint versus just the square footage going vertically.
Thank you.
You're very welcome.
Anybody else? Mr. Eisner?
I did want to make a declaration. I did pass by the house, and I did go to take a look at the situation, that if a garage was built, would it be blocking anybody's view, and I did not find any problem with that garage being built. The sunroom, of course, is out of the realm, except if you're on the water, so. But I did look at it, and I did want to let us know that I was there.
That's a fair assessment, and
I went by there as well. It's the smallest it's the
it
smallest
really is.
building in the entire area. So they're not asking for anything that hasn't already been paved over by everybody else. So it's
Correct.
the same. And they're having to park in their front lawn because they don't have a garage. So again, I don't see a problem with that.
Any further questions? Okay. Ms. Sander?
I just have one. Any
Use
issues,
the mic. Can you speak up?
sorry, any issues with Swift Mud by allowing the slab-on-grade expansion?
No, there would be no issues in this particular case with Swift Mud or that type of thing, because you do not regulate your stormwater management using impervious surface ratios here. So they're free to put those additions on there, providing they provide the guttering and things that are required by code. They would meet those standards.
Same
They're-
thing with FEMA?
Correct.
Okay, thank you.
All right, it's my turn. First of all, what Mr. Alahouzis referenced about the reduction in the lot depth, there was a channel dug. It's a pretty deep water over there, and that's where the loss of land came from. It was scooped up and put on shore. This is a non-conforming lot of record.
I would challenge that determination, but okay. It's a non-conforming structure, whether
But
it's.
it's a non-conforming lot of record according to your report.
Well, based on the
It's
survey, yes.
Based upon the survey, it's not. And non-conforming structure, which means under the code, I believe, and correct me if I'm wrong, that the existing setbacks are grandfathered in.
For the existing structure,
Right,
yes.
and there's no change to the setbacks for each of these two additions to the building.
That's correct. They're in line with the existing setbacks that are there, with the
Okay.
existing home.
But doesn't the code state that if the setbacks are grandfathered in, there's no increase? Oh, I say the problem is that you're expanding the structure even though it's a non-conforming use.
I'm going to address that question because I had the opportunity to research it just before coming here tonight, because as I was reviewing the agenda, I called Heather about this application and said, Heather, I don't think that these folks need a variance either, because I was going by on the assumption that staying along that 17.11 feet on that line was not an expansion of the nonconformity. But as it turns out, the case law in the second DCA says that it is. And the reason for that is that court ties the setback inextricably to a structure. It's not, the way that you're conceiving it, the way that I was conceiving it as well, was I was sort of drawing an imaginary line along the property and saying, so long as that's met, I can build whatever's there along the setback. But that's not how setback is handled by a lot of courts, but most importantly by the second DCA. They tie the structure to the setback. So as soon as you expand the structure, you've expanded the nonconformity. But I understand where you're going from, and I had the opportunity to do that just before I
It is
came here tonight.
Okay, are we ready for the question? Could I, before we get into that, in the future, Heather, is it possible to ask for a rendering or some kind of a picture of what the structure is going to look like? I know it's not in the code, but I would like to see, I'm sure the board would like to see how it's going to look. Is there a way you can do that?
Well, you'd be asking the applicant to provide that, so that would be an additional request for the applicant. And if that's the pleasure of the board, we can look at your board procedures and our application requirements and consider that.
Yeah. Do you don't have a rendering, David, or anything?
We had a footprint which we had turned in.
But we have that.
We have that, sir.
We have that.
An elevation.
The elevation.
Can you get back to the-
Right,
Just,
I'm sorry.
so it can
You
fit in.
talking about a rendering for the,
elevation.
The
Front
elevation,
elevation or
yes.
something?
no.
Okay. You're the same David Green that's built in subdivisions around Sunset Hills, and
Yes.
right?
Yes.
We
Point
had a
Alexis
few, we had a
and-
few bunch of battles over 40 years ago.
Oh, yes,
Good to see you back, David.
yes, thank you.
All right, now, is there a question? Is there a motion?
Motion to approve.
Second.
All right, who's going to make the motion?
Well, there were two Chris's, so pick one.
Flip a coin.
Let's say Commissioner Alahouzos, okay? Made the motion, and
I second.
Mrs. Sander made the second. Any discussion on the motion? Seeing and hearing none, let's take a roll call vote, please.
Mrs. Sanner,
Yes.
Mr. Eisner,
Definitely yes.
Mr. Alahouzes,
Yes.
Mr. Rabowski,
Yes.
Mr. Elliott.
Yes. Okay, congratulations.
No, thank you.
You'll get a letter in the mail. I think you have 2 years to build.
Ready to go to work?
It's a year.
Oh, you got to go through that? Okay, minutes.
What about the minutes?
We haven't approved them yet. We got, thank you, good to see you again.
Good night.
Okay, we have the minutes of our October 28th meeting. Any discussion? All right, is there a motion to approve the minutes?
Motion to approve the minutes.
Okay, second.
Second.
All in favor? Aye.
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 Okay, opinion of the chair carries unanimously. Thank you very much. All righty, next item, staff comments.
The only thing that I just want to bring to your attention is possible based on the fact that we have Citizens Academy that's going to be starting up here in January, which is a program that the city is going to be taking on where all the different departments basically have a night and they present to a group of citizens who are interested in learning a little bit more about city government. It is possible, they currently have us working with Development Services on the 24th, which is your scheduled night in February. If that is the formal schedule that ends up happening, because it was a tentative discussion today, we would probably have to move your February meeting because they may be using this room. I don't know exactly which room they're going to be doing that and where things are going to be, because there's still a question of how soon we're going to get into the auditorium.
You can vote on it in January.
Exactly. I'll bring it back to you in January, but I just wanted to give you guys a heads up, just so you're aware, because currently they scheduled us for the 24th, which would be a conflict for your meeting.
Okay, but in January, we're still going to be off-Broadway in this room?
We'll still
And
be.
we'll get back to being on Broadway in February?
That,
March?
I have absolutely no idea. I know that the contract has some time in February that they have to do the work, so it will depend on whether or not they're on schedule or not. And again, I have no control on that
You don't have
project.
any applications in the hopper at this point?
I have nothing for you right now, but I did talk to somebody at the beginning of this week, so it's possible you'd have an application for January, but I wouldn't have February applications till we get to January anyway.
Right, all right.
Okay, thank you. The next item is board comments.
Mr. Chairman, would you mind if I made some staff comments as staff?
Sure,
before
of
we
course,
move?
I'm sorry.
Just because I was reading the minutes of the last meeting, and I know that there was some question as to whether this board needs to report to the city commission on certain things that it does, and I think that you were advised by my colleague that that needed to happen or should happen at some point. That was incorrect. I apologize on her behalf. She was simply reading from a wrong portion of the code. This board's authority is constrained by Section 215 of the Land Development Code. It does not require you or permit you to report to the Board of Commissioners on really anything. So to the extent there was confusion about that, I wanted to clear it up, and I'm happy to answer any questions you have about it.
Thank you.
Well, certainly we can report, but we're not required to.
I don't think you have the authority to report collectively. That doesn't stop any of you from individually speaking to the Board of Commissioners about things that you'd like to see improved, changed, altered. But as a board, your enabling ordinance does not provide for it.
Well, collectively, as private citizens, we could write a letter to the commissioners requesting changes.
Wait, collectively as private citizens.
I mean, we could.
Which side does that come up?
So,
Well, I was.
You may not act collectively as a Board of Adjustment to make a report, or make recommendations to do anything relative to the Board of Commissioners.
but we-
Candidly, I would instruct the Board of Commissioners to ignore it. Not that your input is not valuable, it's not what I'm saying. I'm saying, as a collective Board of Adjustment, that is not within your enumerated responsibilities, duties, powers, obligations. If the Board of Commissioners sees fit to put that in there at some point as, on suggestion by one of you as a private citizen, that's certainly up to them, but this board could collectively not endorse or advance that effort.
Well, at the last meeting, I suggested some changes to the jurisdiction of this board as well as the procedure. And if that's the case, then I could just write the letter myself.
In terms of this board's rules of procedure?
well, that's a
Well,
separate issue.
Yeah, that's a separate.
we all recognize there's some problems with the code,
Yeah, I read some things about some problems with the code.
and
Yeah.
we all would like to see some changes. For example, I see that we are violating the code every time we pass, pretty much every time we pass an ordinance, a variance, because of their financially based considerations indirectly. And the code says you cannot consider financial factors in making your vote. But we have done that. And as Mr. Hrabowski said last month, there was one major one we did. And if we had just said to the city commission, I'm sorry, we can't pass these variances because your code says we're not allowed to base it on financial circumstances, then they would have found a few bodies in the Anclote River. The sponge boats would have found more than sponges down
Well, I
there.
didn't necessarily a code problem, that's an application problem. Unless, if you want to suggest all the changes you want to the board, but that sounds to me like an application problem versus versus a code problem for, you know,
Well, the code, it's in the code,
Yeah, the code states that
code
you're
states
not
that.
allowed to consider financial
circumstances.
okay. Well, the code,
And it,
at the risk of irritating all of you tonight, because I come to this board frequently, it's not my intention to do that, but I'm gonna give you a, you're,
The attorney stuff.
nothing gets
Okay.
better when the attorney gets involved, as I said. You also have some enumerated criteria in which to evaluate variances, and candidly, I respect your decision, it's not my, but you got a staff recommendation against one of the criteria in the code that couldn't be met tonight. The applicant didn't rebut it at all, and you voted for the, you voted to grant the variance. So all due respect, that's an application issue versus a code problem. Right?
well, we also had a variance last month, which the staff stated that because of the way the code is worded, she had to recommend denial, but she said that, I don't want to speak for Heather, but the code criteria can be made a little bit more flexible
Right, by the Board of Commissioners.
by the Board of Commissioners. Yeah, we're all
Right.
talking about changes to the Code of Ordinances, the Land Development
So
Code.
is this
So
the
that-
purview of the Charter Review Commission?
No,
No.
So
no.
then who would make these?
The Board of
changes?
Commissioners.
Just the
Yeah.
commission?
Yeah, I would hope that.
Yeah, the
they-
Board of
Who
Commissioners
makes the
change,
recommendation, though? Who
The
can?
department.
typically Planning Department.
Okay, so the recommendations can be made.
With the support from the city manager's office, yes, we can make recommendations for appropriate changes. However, those appropriate changes are those changes that are requested. There's no guarantee that staff's going to support them and they're going to go forward. The process would be they go to Planning and Zoning Board, then they go to, with a recommendation from them to the Board of Commissioners for a final decision.
Well, my recommendation, Mr. Elliott, is one that you just write down all the changes that you wish to see and submit it to the Planning and Zoning Department and to Mr. Licouris, and start from there.
Okay. All right, and at some point, we'll get on the city commission agenda, hopefully, and hopefully you can speak for or against. And of course, you're more than welcome to add your own thoughts to that. Okay. Well, any further comments?
Board comments. Well, just, when are we going to address the rules of procedure for the Board of Adjustment?
Can you be on the tape, Chris?
Rules of procedure for our board. When are we going to discuss that?
You want to do it now? If you're ready?
Is there a draft?
Well, we don't have that.
We have rules in place. We have rules in place we were provided,
Right.
and we'd like to make some changes to them, one of which I suggested today with the rendering, you know. You have some other changes proposed?
Well, one thing is accessing the internet. I don't know that that is a major issue, but if we needed to get some information that we could get, it would seem wise to me, not to have it on all the time, but if somebody needed to access the internet to get some data, I think that would be wise to do. And I know that that's something that each board can either allow or disallow, I believe.
You mean at the meeting?
Yes,
Have-
during the meeting.
Have a computer available?
Yes. And again, not that somebody would have any device on the entire time staring at it, buying golf clubs like happened in Pasco County, but just if we needed to get information, that's one way to source information. I don't see a problem with that, but I mean, I'd leave it up to the rest of the board.
I believe if you have an iPad, nobody's gonna tell you to bring it.
Well, there were rules placed, I think, on this board, now the attorney's not here anymore, that we had back, that was Yakavon. But I believe during the Yakavon years, they did not allow it. So I'm just suggesting that we allow it officially. So if we decide as a group that, hey, let's look something up, then we could do so.
Does the city attorney have any comment about that?
Officially allow looking up information on the internet, is that what you're
Yes,
suggesting?
during the meeting.
Yeah, I would, you know, in a quasi-judicial proceeding, you need to base your decision on the evidence that's presented to you at the meeting. Right, you folks are not permitted to present evidence. It happens in quasi-judicial proceedings, but a lot of quasi-judicial decisions are overturned as a result of reliance on evidence inappropriately submitted. So you folks are very much like a judge in these kinds of proceedings. And as someone who tries cases for a living, if you don't get it before the judge somehow, he's not gonna go find it for you, he can't go find it for you. So I'd be concerned about being able to look stuff up on the internet. Same thing, I'm gonna get a little far afield here, but same thing with site visits. Your rules of procedure specifically authorize them, and I'm not telling you they're not illegal or that you shouldn't do them. But the concern that it raises is that you have to base your decision on competent substantial evidence. But let's say that the applicant does not submit that competent substantial evidence, but you've made a site visit, right, and you base your decision on the stuff that you saw when you made your site visit, and the decision is, in quotes, wrong one way or the other, it can be challenged by an absence of competent substantial evidence, because you folks are not permitted to put evidence into the record. You might have knowledge, of things that have happened in Tarpon Springs beforehand, even relative to a property that you're considering. You might know the applicant, or you might know stuff that, were it in evidence, would sway your decision. But if it's not actually in evidence, you can't base your decision on it. So for that reason, I'd be concerned about, having access to internet on the dais here as you're considering applications, because it is the applicant's job to support the application. It's the staff's job to provide you with the information they have in their possession and their evidence, whether it's for or against, and that's the evidence that you need to be relying on.
I have a question for you as I'm listening. Today, we're listening to this case, and in this case, they did not give us a diagram which was asked for. They have the plans, but there's no diagram. Now, myself going over there to look at it was a wealth of information for me, because I got to see, building it to that height, what it would do to impact the neighbor to the right, the neighbor to the left. So are you saying?
You're talking about the second application?
Yes.
Well, that's a perfect example. There isn't anywhere in your code of ordinances that says the impact on the neighbors is a criteria to gain a variance under the code. It's not in there. So going out there, and if you base your decision, if that application had been heard and you based your decision on the impact to the neighbors, either positive or negative, and that decision was not supported by competent substantial evidence, it'd be overturned one way or the other, because that's not one of the criteria. You got to base your decision on the criteria in the code. I know that frequently, especially in variance hearings, we always get into, well, what do the neighbors think? We do these a lot on the beaches. It's always really interesting, because everybody out on the beach wants, the code provides for like a 35-foot dock extending from your seawall, and they all want, well, I got to have 65 feet because I just bought a 200-foot boat and I need, really deep water. Well, that's all well and good. Well, the neighbors don't object. The neighbor's objection isn't relevant at all.
Yeah,
in most codes.
Right, I wasn't looking at it for a neighbor's objective. I was looking at it as just driving down the street, what it would look like, because it is a garage sticking out. Like I said, the sunroom in the back was no effect. It was within the footprint. But the front, how far it would stick out would be offensive, not just to the neighbors, but to anybody driving down the block.
Right, but in as much, I understand what you're saying. I know that it can be helpful in circumstances. That's why, but it can get very confusing, because that application had to do with a setback issue.
Right.
So unless you were out there, and even if you were, it wouldn't have made a lot of difference. If you were going to evaluate, all right, well, they want 3 feet into the setback. How's it going to look if it goes 3 feet into the setback? Is it going to look bad? Is it going to shade the neighbor's yard? What's it going to do? Helpful, perhaps, for you to visualize what you're looking at, but you've almost relieved the applicant of the obligation to present his case and provide you with competent substantial evidence. That's their job. They've got to do it. I know a lot of them come and they're not prepared, and that's unfortunate, but if you base your decision on what you saw out on the property without any corroborating evidence at this hearing, you have a potential problem with the proceeding. And it's very difficult. It puts you guys in a real difficult spot. I understand. I do.
Staff, though, does bring up whether it does affect other people's sight, whether it has overhangs. In many of the cases that I sit and listen, that's what we discuss, though.
Specifically, what staff is getting at is granting of a variance will not substantially diminish property values in the surrounding area, substantially interfere with or injure the rights of others whose properties would be affected by the approval of the variance, alter the essential character of the neighborhood, or create a nuisance. That is what staff is charged, is one of the criteria that staff is charged. It doesn't specifically look at the individual needs of either neighbor on either side. It's looking more at the neighborhood as a whole. Is this going to provide some type of nuisance, or is it going to cause some kind of, unintentioned issue that would occur as a result of granting that variance? That's what staff has to find as a positive. But it's not an aesthetic issue of what does it look like. It's a question of if this setback is allowed, is it going to impede on the enjoyment or cause injury to adjacent property owners? And adjacent means the entire neighborhood. It's not meant to be specific to just those adjoining property owners.
Well, then let me retract what I said, because I wasn't speaking then for either neighbor on the sides. I was speaking for the neighborhood in general, and I still feel that you still need to go and take a look at the property for the mere fact that the people will not be always providing that for you.
Yeah, and that's why I specifically say it's not against the law, I just don't advise it. I would much, your decisions here from a quasi-judicial perspective are much cleaner if they are based only on the evidence that was presented to you. Now, and I understand, because sometimes when I read the stuff on paper, I don't get it either. And to me, a visual is very helpful. That's why, you guys can do some things with your rules of procedure to maybe help you do that. Again, going to the property where it's helpful it's not against the law. I'm not instructing you not to do it at all.
I'm just going to say, for the record, Jim Yakabone recommended that those boards, the previous boards, not go, and also not use the internet. But when we did training with
Correct.
with the Ms. Kardash, she recommended that we do go.
And the training for the quasi-judicial training is to go, and even
Right.
so much so that if another one of the board members are there, you could be there at the same exact time with that same board member and say, how are you this afternoon, but you can't discuss the
Right.
situation.
Well, that's another reason militating against it. And I'll speak to Regina about that. So in as much as there's an inconsistency coming from my office, my apologies for that. And just as a recommendation, I certainly wouldn't recommend that you do it. I strongly recommend against it. It's not illegal, though. I understand, bear in mind, you all have to make your own decisions. You guys are here, but you're sitting as judges. Unless specifically requested in a trial, a judge doesn't go out and go, I got to get a look at what this looks like. You got to give them the evidence. And so it's a cleaner process. I recommend against it. In the future, Regina will be recommending against it. But that doesn't mean you can't do it.
Ms.
Doesn't mean
Sander?
you can't do it.
Based on my past experience, you have to trust staff. The information they provide to you, to us, is what you need to base your decision on. You cannot, going to the site will bring emotions out in you, and this is not an emotional board. You have to act on what facts are presented to you. And I think by going out to the site, you kind of compromise that a little bit. But it all lies in trusting staff. And you have to believe in them, and you have to respect the information that they provide to you, and you need to make your decision solely based on what is provided to you. And that'll keep you out of trouble.
It's just, honestly, it's confusing to me, because in the instructions, I'm told one thing.
Yeah.
Here, I'm sitting here being told something
It is
different.
confusing, and I apologize in as much as that confusion came from my office. And I'll tell you that, within the firm, we represent 11 cities and towns, as well as some other judicial boards. And it's hard. They're all over the place. It's not illegal to take a site visit. So you're gonna, at the end of the day, that's why I ultimately say that it is your decision. If you think it's gonna help you, my strongest caution to you is, whatever you've learned at a site visit, you need to base your decision on what you've learned at the hearing. If the site visit is helping you visualize things to get a sense of what the application is about, good, okay? But you need to, and it's hard for the human mind to do this, but you need to then compartmentalize what you've seen at that site visit and say all it did was provide me some illustration and provide me some context, but the evidence now is what I need to consider.
I agree.
And there are some boards out there that frankly, I represent a board in the city of Clearwater that specifically requires it. But they do legislative hearings as well, so it's a little bit of a different animal. In a quasi-judicial proceeding, frankly, I recommend strongly against it. Again, I can't say enough, doesn't mean you can't do it.
Well, I'm a visual person, and so for me, it is helpful to go and see it. If we maybe had to review 15 to 20 different variances, I could understand I wouldn't have the time and the wherewithal to do that. We're a small town, and I think I don't voice my opinion on any one detail. I do take in the entire situation. This is just one avenue that helps me to at least see where, who, what, where, when, and why. And I understand that, so I would like to be somehow or other in a position where I would be going to some sites when I can't follow it on plans.
Could I make a suggestion? I hear from everybody saying, and you're all making sense, and I've changed my thinking about having a view a little bit as well after hearing this, but if we were to put in the application something that says that the applicant acknowledges and agrees that the board members may have a view prior to the hearing, and the applicant would have no objection to that, first of all. And then secondly, at the hearing, we would state, when we talk about our ex parte communications, we would state whether or not there was a view made by each member. What do you think about that, Mr. Attorney?
Well, a view is not necessarily an ex parte communication. The communication comes in when, of course, you speak to somebody on the property or speak to somebody regarding the application outside of this hearing.
But that's what
Outside of
you're taking evidence outside of the hearing by going to the property and looking at it. My question, if we were to disclose that, and if it was agreed to by the applicant in advance, would that soften your opinion at all?
No, my opinion on this is pretty much what it is, and it happens all the time, Mr. Elliott, you know that. So it doesn't change my opinion, because I just think it's difficult for the mind to distinguish, you know, what I learned to visualize the application, visualize the property versus what is evidence. The concept of evidence is difficult to begin with, and when you start muddying up with what I see.
Like the applicant today on South Spring Boulevard, I represented the family for 40 years. Capsalis family. I've been in the property 50 times. Would I have had to recuse myself?
Absolutely not. No, you have no conflict.
I've been to the property, I've seen it, and
And that's kind of assumed in.
so had I been there for 50 times in prior years as opposed to last week, is there any difference? I know what the property is like. I've been inside and out.
To me, the difference is you don't have to, when you walk in the door of that room, you don't leave all your life experiences behind. If you're visiting the property specifically for purposes of evaluating a variance application, I think there is a large risk that your decision may not thereafter be based on the evidence presented at the hearing. You know, of course, we live in a relatively small community, right? You don't have to divorce all that stuff from, you know, your experiences, the people that you know, the things that you've seen when you walk in that door, but you do have to sit as judges, and as judges, you have to take the evidence.
Would it help if a photo was submitted? Would that suffice as opposed to a site visit?
It's not just that, and I'm not trying to be obstinate in this.
No, it's okay.
But the bottom line is, when I went for the course, that's what they said. They said you could and should go to these sites. Now, this is right around the corner from where I live, so for me, this was walking distance.
Yeah,
So it was like a no-brainer for me not to go there and take a look.
I understand, okay.
Well, you got the opinion of the attorney, so
Yes,
you
I
decide.
see that.
You decide.
What are your thoughts, Chris? About whether to go, is it okay to go to the property we're talking?
Well, there were times that I went as a commissioner, and of course, as long as you disclosed that information was okay with the previous city attorney. But every city attorney has his own opinion, so.
Well, we have two of them sitting here.
Well, you have any thoughts? Have you said your thought?
Well, I mean, I just was stating for the record that I happen to know Yakavone told them not to go.
But would
And,
you like to go?
and yes, I've been to every single one of these applications. But I was also advised to do that in my training on the very first day by the city attorney that we had, Ms. Cardash. So, yeah, I stand by that. I think it's wise to get a good idea. I mean, I wouldn't have known that there was a garage, ugly garage, sitting out in a property that was literally next door to the one that we were voting on. That, I mean, that was, you know, if I hadn't, because that wasn't in anything that was presented by the city or by the applicant. And there was no opposition to that man, but I happened to drive by and see that. That was important information for me.
Yeah.
Because it was, they were essentially getting away with what the other people were somehow being challenged.
But to me, the city attorneys provide us his opinion to be able to defend him if something happens. So
Give him a
I can understand his position, why we do it.
Yeah, I don't take it personally, by the way. I have contact Norma advice all the time.
Yeah, my thought is if we could put in the application that the applicant gives us the right to do this, that would soften the consequences of going to the property prior to the hearing. I went there too, just to see if I had any conflicts of interest, for example. I might know somebody across the street, that sort of thing. So I would like to have the right to look at the property myself, but I understand the city attorney's perspective, and would like to find some way to do that to where everybody's happy. That's one thought, is approval in advance and then disclosure at the hearing.
I'm for that.
I mean, I like the sound of that. I don't disagree with it. Or are you suggesting that we put this into our rules of procedure, or?
The attorney can discuss that with, is that the appropriate price, Mr. Daniota? If we put these provisions into our rules of procedure, is that possible?
You presently have it in there now, as I recall your rules of procedure. I don't have an encyclopedic knowledge of them, but I recall that
Well,
they
we
were
need the
in there
internet.
somewhere.
That's my whole point. We could look it up.
Yeah, this is from 1998. I think this is your present rules of procedure. And it says this: inspection trips made by an individual board member to the site of any pending application before the board are permissible. Inspection trips by more than one member pose a potential violation of the sunshine law if the members engage in a discussion of the matter. That's all true. Inspection trips are permissible. That's my opinion. I think that's perfectly supportable. I mean, I can change your rules of procedure to say that they are heavily discouraged by the present city attorney in 2015, pending the further review by subsequent city attorneys. But,
Okay, well, I'd like to leave it in there with the caveat that people would approve that in advance and they know that it's happening.
I
And
agree.
also, I'd like to see something in there about a rendering of photographs or something, if we could do that. I know it's, we can't look at it, we can't base our opinion on aesthetics, imagine, but we can also, I'd like to know what it looks like before we say yay or nay, if possible.
You can ask for renderings, but basically, majority of what you are reviewing is a question of the footprint, the setback, the
Sure.
site plan
I
is the
recognize that.
appropriate tool for that thing. A rendering is putting an undue burden, at least in my opinion, on an applicant for this particular board. Now, do other boards have requirements for renderings? Absolutely. Heritage Preservation Board requires them, but the type of work that they're doing, it really requires that type of detail, the level of detail. Same thing with the planning board when they're reviewing new subdivisions and new commercial developments. The detail that they need to be reviewing requires that level of detail. So we can certainly request it of applicants. I don't think you can require it of applicants because it's not a necessary piece.
I
But we
agree
can
100%.
certainly ask applicants to provide visual aids, to help,
Is that okay? Everybody agree with that?
to help with
I
you
agree
guys
100%,
visualizing
sure.
the property and what they're asking for. And sometimes they will bring us like the sheets if they're adding a screen room or that type of thing so that you actually can see the material lists and sheets, but those are few and far between because we don't do a lot where it's it's, it's an additional room, usually it's a built-on room.
I guess the other thing that I would like to, now that we're onto this, is, I see these aerial photographs. I mean, there's an enormous screen right there. If we had access one more time to the internet, and we could, just with this tablet, you can do this and get all the way down and see what every single property looks like in that region, right? You get immense detail. It seems like that would be better for everyone involved to get real information instead of trying to figure out what that is right there on paper. So again, it would just be, it's more information. I don't see why that would be a bad thing.
When we get downstairs, we can do that? Is it-
Well, downstairs they have
That's
you have
kind-
that screen. Could you broadcast that? I don't mean to make your life miserable, man.
More
But they do
miserable.
have Chromecast. You can broadcast it from a tablet. Is that doable?
Not with the system that we have set up down there now.
Okay. So when are you going to update that?
Can you provide money?
So while that's doable here, that's not a solution long-term because
Not yet.
it's not set up down there for that to do that, at least for the general public that's viewing us online to see those things, where they
Okay.
can access the paper copies on the internet via our website, and then also look at the video at the same time. If they want to go back and forth at home, they have that ability to access that. Us putting it on that screen, it's really hard for us to even see that screen in that room. It'd be really impossible for folks out in, to see, especially when you get down to the detail, because as you zoom in, you lose contrast, and the detail gets pixelated.
Well, I want to say something as well. The other variance that we were looking at that was tossed out, I found it so difficult to see what the overhang was. There was no measurements on it. It looked like there were windows all the way around, even where the knobs are to turn the faucets on. I had no clue what I was actually looking at, and I'm a contractor. So, I mean, some sort of visual, I think, would be advisable, better than what was presented, because I found it very difficult to understand.
The second application, that was a non-application?
Correct.
Okay.
Have we exhausted this item, do you think? Any
Well,
further discussion?
what other items on the rules of procedure were of concern?
I think that's all I have.
While we're on a roll,
Point being, you want to have a vote at our next meeting?
Well, I
Sure.
just figured we'd cover it today, and then the
Yeah.
next meeting we can do something about it.
If y'all want to continue to discuss it, I'd suggest directing Regina to make, do a draft rules, changing what you want changed, and have it bring it back to you for
The
approval.
one thing I brought up last month was the change from amending the application instead of saying less restrictive to saying as long as it's immaterial. Remember? Shall I explain a little more what we're talking about? We had a variance application a few months ago where, because of some kind of error somewhere, the application said we want an 11-foot variance, when in fact it was a 12-foot variance. Well, we heard the application, even though the amendment was to increase the variance. And I think we did the right thing, but I'd like to have the rules state, we can allow the amendment so long as it's not material.
And I'll give you the counterpoint, just because I drew a short straw tonight.
That's what we got you for.
An applicant for a variant has to prove by the competent substantial evidence that he's asked for the minimum possible variance to make reasonable use of the property. You're essentially, most of my adjustment boards are not permitted by procedure to pass on anything other than the application as submitted, because it was their burden to submit the least amount of variance they requested, whether it be, a 10-foot variance where 6 would do, or a 38-foot dock where 35 would do. That's their burden, and to place that burden on this board, I think, creates problems. The second thing is, if you use the word material, material means different things to different people. What you find material, I may not find material. The courts may not have a different opinion than all of you. So most of our boards of adjustment are not permitted to pass on anything other than the application before them. If the applicant wants to change it and come back, they're certainly welcome to do that. But we typically recommend that they come in and say, I want 6 feet. Okay. And then the evidence at the hearing shows I want 4 feet. Okay, well, you got to come back now. I know that it sounds harsh in result, but it's their burden to prove that they've requested the least amount of variance that is
You're
permitted.
saying if they ask for less than what the application is for, they have to come back?
If they ask for anything different than what the application,
Could
I
they-
think you're putting a burden on these people that are.
Could they, in that case, could they ask the board to continue the application? That way it doesn't have to be re-advertised, because obviously I don't want to continue to charge people for ads because they get very expensive, especially when each time things, so.
Not to mention, you weren't here for the January meeting, but the very first one we had a gentleman that had, I think, 5 different renderings.
Yeah,
Chris, you
that's
remember
never
this?
going to happen again.
That guy had so many different.
That's
Well,
never going to happen again.
All right, I'm just telling you that was my experience.
I don't, we have a lot of people that are not
That's
very
not gonna happen.
sophisticated. In fact, the one I'm talking about was 1112. This is a
Mm-hmm.
general contractor, city employee for 30 years, and just it came out with a minor little problem that we resolved.
And in the particular case, I think that you're talking about, the variance that I remember that we talked about and that this was adjusted on, the actual evidence was part of it was part of the actual site plan, which was part of your backup, and it was just incorrectly identified by them, and staff missed it because their drawing was very difficult to read because it'd been
So that's
been
an
used.
immaterial difference that I'm saying that we can, based upon the board's knowledge, can say, as a board, not individually, that it's not a material problem.
But in that particular case, it wouldn't have been overly burdensome for the applicant to ask for the continuance and us to fix it the very next
But
meeting.
it also would have
to-
been common sense to go ahead and hear the application as amended, in my judgment, anyway.
maybe some of the disconnect from my end is this. You know, the general law of variance is that variances are to be granted infrequently, truly infrequently. They are the exception and not the rule. And some of that is based on the idea that the more variances that are granted, especially when you see a lot of setbacks, you see a lot of stuff like that, they have the effect of amending a city's code without the required legislative desire or approval. You know, you're essentially zoning by fiat, and that's not this board's function. So in as much as you get into issues of amending variance applications at the hearing, again, you're simply going further down that road to me. I know that, and I agree with you, Mr. Elliott, that a lot of your applicants are unsophisticated. Many, most, if not all of them, come without representation, which I think is frequently unwise, especially in a quasi-judicial proceeding. Nevertheless, variance is being the exception rather than the rule. To the extent it operates harshly, it really needs to operate harshly against the applicants and those seeking variances versus operating harshly against the city. Because you're sort of robbing the Board of Commissioners of the opportunity to zone by legislative desire. They'll get the input of the experts on the planning side of things to say, this is what the code should be, this is the way the code should change, and so the variances will be ideally few and far in between.
I think they are. We've gotten, in a year, maybe 20 variances out of how many permits have been applied for? Hundreds, if not thousands. And the Board of Commissioners has given us the authority to make these changes. There have been no objections from them. I believe in common sense, and I believe in flexibility myself. And the Board of Commissioners is not omnipotent. They can't see everything in every particular case. And I think they recognize that. You have this enormous thick book with all these little rules. You've got to be 25 feet from this property line. Well, I want to be 24. Neighbors don't care. And they have a reason for it. Maybe it's okay. You know, they give us the flexibility to do so, and as long as we don't abuse that authority, we give notice to everybody. On a particular case, the Board of Commissioners designed for policy reasons. We got 2 ex-commissioners. You don't need to be messing with little things like this, in my opinion, being up here for 40 years. That's what we have this board for, and other boards of similar input. In fact, they have far more jurisdiction in Pinellas County than we do. I just went and gotten their agenda from the Board of Adjustments of Pinellas County, and I'm looking what their Board of Adjustments authorized to do, and it's far broader than ours. So I personally, again, this is a personal thing that, based upon my experience, I believe that the Board of Adjustments is a good board to have as long as we do the job correctly. And from what I've seen up here, we've done that. The Board of Commissioners has not objected. And so it's a philosophical difference, and I recognize that, but you
You
can't.
also had a question about alternates. Didn't you want an
Yes.
extra alternate?
Yeah, the charter has 2, and the code has 1.
So what do you want to do about that?
Well, the city attorneys, Regina said that the charter prevails, and we can have 2 alternates. Is that was going to be in my letter?
Okay, on this board?
Yes. The charter says there should be 2 alternates,
Oh, is that right?
and the code just says 1. And we're fortunate to have Ms. Sander here tonight because now we have a full board. There were times a couple of years ago where they didn't have a quorum for 6 months.
The city clerk is going through some of the, to correct some of those mistakes that it's on there, to make sure that the code is actually applies with the charter. They're working on that.
Yeah, we've been working on that for some time, and I think that effort's been, that's been going on for about 15
Have we
months.
exhausted this?
I think so.
Okay. Is there a
Almost
motion to
argued.
adjourn?
Motion to adjourn.
Second.
But before I do that, I'd like to wish everybody Merry Christmas and Happy New Year.
Thank you.
Merry Christmas as well.
Thank you.
Okay, same here,
And Happy Epiphany. Good night.